The Law of the Sea Treaty briefing. Will U.S. sovereignty be lost?
I think that the best thing for me to do at this particular juncture is to bring us back full circle. The debate that is surrounding this treaty at bottom is really about the proper relationship at the international level between sovereign states, or whether they will no longer be sovereign. You've already heard about the Medellin case. Before the court right now is a fundamental question of whether international institutions will be able to reach beyond the boundaries of sovereign nations, and in our case, our Constitution, and reach down and affect the procedures that we have in place under our Constitution, and for that matter, state and local law, to manage their affairs. In this case, in a criminal area, but in other treaties with other matters, and it will affect other areas. I think I want to make fundamentally 2 points. One is this connection between the Medellin case as one of many sources of pressure to, quote unquote, supersede the concept of state sovereignty, and the other is the domestic aspect of that debate, and the question of individual liberty that I think is at stake here. There are two ways that the Law of the Sea Treaty could be used at the international level to impinge on U.S. sovereignty. The first, and the one that you've heard about most extensively so far, is the mandatory dispute settlement procedures. John Norton Moore, legal scholar at the University of Virginia, and a strong proponent of the treaty, says that this particular treaty is among the most important law-defining treaties of the 20th century. The reason he says that is because the law that is being defined here is the law by which international mandatory dispute settlement procedures will be used to dictate what actions nations may or may not be allowed to take, and that the exclusive authority for those decisions will rest at the international level in these international institutions. The second and less formal process at the international level by which American sovereignty could be impinged by this treaty is one of what I call mere interpretation. There are all sorts of anti-American interest groups internationally that look to broad or vaguely defined language in treaties, and this treaty is as sweeping as any you can imagine, to interpret those particular provisions, vague though they may be, in a certain way. The problem that we face is, of course, a treaty, once it is ratified, is effectively statutory law of the United States. And increasingly, judicial authorities are looking at foreign interpretations of these provisions to drive the definition of what is required by U.S. law under the treaty. Well, what if there is a conflict? In the Law of the Sea Treaty, with its sweeping environmental provisions, the environmental aspect is the easiest thing to look at. The Europeans interpret the Law of the Sea Treaty's land source basis for pollution and say, we interpret this treaty a particular way. And that may be, in my version of it, over-complying with the treaty. But nevertheless, you'll see domestic interest groups go into court, I think, under this treaty and say, the Europeans are interpreting this certain way, this EPA regulation is incompatible with that interpretation, or that U.S. statutory law is incompatible with that interpretation and the treaty should prevail, and judges will increasingly say yes. Now, on the national security side with regard to that is that they say that the Navy and all military activities are exempt from the treaty. But nowhere in the treaty are those military activities defined. And I think that it is all but certain that some future administration will say that a particular action that our military services believe is a military activity the treaty is not. And civilian authorities will overrule the military authorities in terms of determining whether they will be subject to, for example, a mandatory dispute settlement procedure that is established by this treaty. But if you think that it is only a question of foreign sources that are bringing the pressures on American sovereignty, you would be wrong. At bottom, this is a domestic ideological debate. There are predominantly liberal sources who believe very much in the idea of moving beyond the concept of state sovereignty and believe that the institutions that we've established here in the United States, specifically for the purposes of expanding individual liberty, are in fact expendable, that they can be bypassed, and that in the interest of this greater global good should be bypassed. Now, why is it that this is such a dangerous concept? It comes down to the question of you as an individual, the authority of your senators in terms of how they manage the affairs of the United States as elements of a sovereign state. What will happen if we go down the road that liberal ideological proponents are leading us in terms of global governance is something that will undermine individual liberty. The United States Declaration of Independence claimed sovereignty for this country in service to freedom. My judgment is that liberal activists are chafing under the restrictions that both our Constitution imposes and our political traditions impose in terms of them managing what they see as a rational society. That they, the elites, and now it will be a global elite, will make the decisions that will affect your daily lives because they know better than you. It is an utopian vision, and individual rights are most at risk when they are likely to be trampled upon by self-appointed elites pursuing utopian visions. The fact of the matter is that liberty and American sovereignty are indivisible. They are indivisible because of the way that this nation was founded and the mission that it pursues in the world. The law of the sea treaty is a fundamental departure from that recognition. And therefore, in my judgment, it is an attack on the liberties that we enjoy here. And let me finally say, as it relates to the institutions of your bosses, and this is something that came up in the Medellin case, if international tribunals can overreach state sovereignty, your bosses and their constitutional responsibilities will be relegated to essentially an administrative function. This is something where U.S. courts will be saying, oh, we're here really to enforce only international judgments. Or if the Senate of the United States and the House of the United States pass, for example, an environmental statute and regulation from the executive branch says we should do this, but the international authorities say otherwise, then that law can be thrown out. And so that there is so much at stake with regard to whether this vision, as embodied in this particular treaty, will take a major step forward. It is not worth the risk. And so that I hope that you and your bosses will consider the full ramifications of what we're talking about here, because it is really about the fundamentals.
The Law of the Sea Treaty Briefing. Will U.S. sovereignty be lost?
For more information, log on to heritage.org.